The lady has already clarified it, and this counter affidavit is by her, that it was in the name of family peace or arrangement that they had taken such a stand that the
namely that the victim has filed a case alleging that her father-in-law pressurized her to name the petitioner in the subject FIR with the aforesaid allegation that the SHO of the case has been given a show cause notice for not registering the case under section 376 in the first instance.
May your lordship be pleased, my lord.
Yes.
I be permitted to state the indulgence of the honorable court. Your lordship may kindly have the last order, which was made on 3/1/52, my lord. Provisional bail was granted. There, my lord.
Just give me 1 minute. Yes, Mr. Rajendra Nayan. Did you take instructions in the matter?
I have a fact counter affidavit.
What have you said?
My lords, the stand is, my lords. Firstly, my lords, I may point out that long ago, section 83 CRPC proceeding action had been taken. That was on 26th of October 21 itself. That was not known to me at that time when the order was passed. Matter was heard on 3rd of January. Therefore, I have annexed that order. Secondly, my lords, the SHO has been so caused for filing or registering the case only under 354, not 376, even though 376. Thirdly, my lord, so far as that aspect that he says,
That's the only aspect which I would require an
Yes,
answer
yes.
from
So
you.
far as that aspect is concerned, the lady has already clarified it, and this counter affidavit is by her, that it was in the name of family peace or arrangement that they had taken such a stand that the previous case number 221 was not filed, but that was never her intention.
That we don't accept it.
That she
This only disturbs family peace.
that she has
Now the
stated.
only ground therefore is that she is an absconder and therefore we will not exercise that jurisdiction. That is useless. In fact, the prosecution should be launched for this false implication.
No, it is not a case of
How do we know?
Lords, that case
But
piece
the ground raised by you, we would have confirmed the provisional bail, but for the fact that he is an absconder. And that the Supreme Court in very, very clear terms, there cannot be any doubt, recently only. Yes, Mr. Pathak.
Yes, my lord. It is a.
Mr. Pathak, the only thing which comes against you now, otherwise I would have, you have seen the view of the court, we would have confirmed your provisional bail. But this fact was neither told by you, you may not know, nor by him. So therefore, you surrender, we will say, we will record, we will give such observation that will fetch you bail before the court below.
I always go down with the observation which will come from the mouth of the honorable court, my lord. But it is a case, my lord, prima facie,
They are not on merits.
it is a concocted
No, we are not on,
misleading.
Mr. Pathak, why don't you understand, we are not on, that we have, that before you could open your mouth, you have said that.
Yes, my lord.
Well, then,
Cause of action, the informant had.
heard Mr. You write what Pathak?
Yes, my lord, the second part.
Heard Mr. S.N. Pathak, learned advocate for the petitioner, and Mr. Rajendra Nayan, learned senior advocate for the victim, opposite party number 2. The petitioner seeks bail in anticipation of his arrest in connection with so-and-so. In connection with so-and-so, pura second paragraph. Later 376 added. Stop. On 3/1/2022, taking the statement of the counsel for the petitioner, namely that the victim has filed a case alleging that her father-in-law pressurized her to name the petitioner in the subject FIR with the aforesaid allegation. The petitioner was granted provisional bail and case diary was called for. Stop. Today, Mr. Rajendra Nayan, senior advocate, opposing the prayer for anticipatory bail of the petitioner, has submitted that the petitioner had been declared an absconder a long time ago, which fact was not known to him till the last occasion when he addressed this court. He has further submitted that the SHO of the case has been asked for a show, has been given a show cause notice for not registering the case under section 376 in the first instance, but only under section 354 and other minor sections of the IPC.
Yes.
Stop. Lastly, it has been submitted on behalf of the victim that the case about which the petitioner has talked was only a compromise, was only an arrangement so as to maintain family peace and respect of the party, family peace and respect in society, respect of the parties in society. Stop. The aforesaid explanation of the victim does not appear to be trustworthy, does not appear to be acceptable prima facie. So be that as it may, considering the fact that the petitioner has been declared an absconder, I am not inclined to extend the privilege of anticipatory bail to him. The order for provisional bail is hereby recalled. The application for anticipatory bail is rejected. The petitioner ought to surrender before the court below and seek bail. Should he do so, his application shall be considered on its own merits, taking into account all the aforenoted facts, and an order shall be passed without being prejudiced by the fact that the present petition has finally not been entertained by this court.
It's only one side, so far as that part is
Not acceptable.
Lords, that your lordships are correct.
Where-
But if a still better word can come from your lordship,
No, you're
so
right.
that it may not affect the future proceedings.